Welcome to Direct US Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I am an immigration attorney with almost a decade's worth of experience, and today we're going to talk about what to do if an H-1B holder has been laid off from their job. Stay tuned. My name is Maitreya Brown, and I am a U.S. immigration attorney based in Washington, D.C. I am also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get a bonus tip on navigating whether the 60-day grace period is available to you and when accruing unlawful presence kicks in. Layoffs for H-1B holders can result in tough times because there is limited time to find a new employer to file a new H-1B petition, apply to change status, or depart the United States without violating status. Even a one-day gap after the 60-day grace period expires means that the foreign national must leave the United States to allow USCIS to reinstate their status upon reentry. H-1B workers who ignore the rules may face difficulty returning to the United States, or if still in the U.S., may even find themselves in removal proceedings, previously known as deportation proceedings. Employers who ignore the rules may also face steep penalties and even fines. So let's review the options available to improve an already unpleasant situation. First and foremost, it is imperative to speak with an external immigration attorney or an authorized internal immigration representative of the company to ensure you take the steps to remain in compliance with the visa regulations. Now, there are 7 things that you should be aware of. First is seeking new employment sponsorship. So the primary purpose of an H-1B visa is to work for a specific employer in a specialized occupation. After a layoff, the H-1B holder may actively search for a new job with another employer willing to sponsor their H-1B visa. The new employer would need to file a new H-1B petition on behalf of the individual before they can start working. That petition must be received by USCIS prior to the 60-day grace period expiring. Number 2 is H-1B portability. If the H-1B holder finds a new job with a different employer in the United States, they may be eligible for H-1B portability. This allows the worker to begin working for the new employer as soon as the new H-1B petition is submitted to USCIS without waiting for the approval. However, certain conditions must be met, and it is H-1B specific with respect to whether the new employer is a CAP subject or CAP exempt employer. Number 3 is the grace period. USCIS provides a grace period of up to 60 days for H-1B visa holders who have been laid off or terminated from their employment. During this period, the individual can remain in the United States and explore new employment opportunities or even new visa options, or make necessary arrangements to depart the country. Number 4, change of status. If the H-1B holder cannot secure new employment and is eligible for a different non-immigrant status, they might consider applying for a change of status. For instance, they could consider changing to a B1, B2 tourist visa, an F1 student visa, or another suitable visa category. Number 5 is the green card, either through an adjustment of status or through consular processing. So if the H-1B holder has an approved immigrant petition, which is Form I-40, with an immigrant visa number available, or is eligible for a green card based on a family sponsorship or another category, they might consider applying for a green card to become a lawful permanent resident. The applicant may do this while inside the U.S. through an adjustment of status or outside of the U.S. through consular processing. Number 6 is H-4 dependent status. So if the H-1B holder's spouse also holds H-1B status, the laid-off individual might consider changing their status to H-4 if they meet the eligibility criteria. Depending on whether the spouse also has an approved I-140 will dictate whether the H-4 visa holder may apply for work authorization. And number 7 is returning to the home country. So if none of the previously mentioned options are feasible or desired, the H-1B holder may consider returning to their home country after the layoff. Be sure to maintain lawful status during the grace period and make the necessary travel arrangements. It is important to note that the employer is required to pay the reasonable fees for a return ticket to the visa holder's home country. Overall, it is essential to consider the specific circumstances, immigration history, and the future plans before deciding on your course of action. Seeking legal counsel from an immigration attorney will provide the H-1B holder with personalized advice and guidance to navigate the post-layoff or termination situation effectively. Drawing from my experience in large tech companies, financial institutions, the film industry, and several other industries, I found that understanding your options early on is crucial when facing a mass layoff. This knowledge allows you to make well-informed decisions whether you're considering employment with another company, changing your status, or returning to your home country. It's vital to explore all potential avenues, and maintaining compliance with visa regulations is non-negotiable and of utmost importance. As promised, here's some bonus information that you may not know about. Now let's talk about understanding the availability of the H-1B visa grace periods and unlawful presence. So there are circumstances where the H-1B grace period is not fully granted by the Department of Homeland Security through USCIS. The grace period can either be shortened or completely refused due to fraud, unauthorized employment, or criminal charges. If the visa holder is outside of the grace period and is still physically present in the U.S., the visa holder will start accruing unlawful presence. If you accrue more than 180 days of unlawful presence, but less than a year, then you will be barred from re-entering the United States for 3 years. If your unlawful presence exceeds 365 days, you'll be barred for 10 years once exiting the U.S. I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.